Good afternoon, everyone. Welcome. I'm Dan Hamilton. I'm Dean of the Law School here at UNLV, and I just want to welcome you to our our inaugural Gaming Law Speaker Series talk today. This is the first of four terrific talks that are being brought to the law school, and we have a particular debt of thanks to Tony Cabot, who is our new Distinguished Fellow in Law and Policy, and Gaming Law and Policy. Thank you, Tony. We're going to have a proper introduction from David Stern, who is the head of the Gaming Law Society here at Boyd. But I did just want to thank you all for coming to hear Terry Johnson. He is, of course, known to me as a Boyd alum. It's a great honor to have him back at the law school. He is Exhibit A of why we needed a top public law school in Nevada. While he had a career in the Sandoval, working for the State Business Associate, and then he was the State Labor Commissioner for Kenny Gwinn, and while he was in that role, he decided to go to law school. And he went to law school in the evening, primarily, and has gone on to all sorts of greatness, which we are, of course, glad to see, including service on the Gaming Control Board, an alum of the law school and the Gaming Control Board. He has been a distinguished alum of the law school, our highest award that we give to our alumni, and he's also been recognized as Attorney of the Year by Nevada Legal Services and by the Nevada Bar Association. And we were just talking a moment ago, he credits that commitment to pro bono and to community service to something he learned at the law school, which is something we really do want to emphasize on and on. I can't resist the opportunity to say a special welcome to a few particular friends we have at the law school, including Jeff Silver. Thank you very much, Jeff Silver. He's been a legendary figure in gaming law for a long time. Thank you, Jeff. From the Gaming Commission, I see Senator Douglas Morgan. Where'd you go to law school?
Yes.
She went to Boyd Law School. Here, I see Stacy Papadopoulos, the CEO of the American Gaming Association. Thank you for being here, Stacy. And I want to put in a quick plug for this. What is this, Ariana?
That is our last issue of the UNLV Gaming Law Journal.
Yes. And if they don't subscribe, should they subscribe?
Yes, absolutely.
Yes. So, as the editor-in-chief of our Gaming Law Journal, she'll be happy to sell you a subscription as soon as today.
Correct.
There you go. So, David, come on up and introduce Terry properly. Here's David Stern.
Dean, thank you all so much for coming today. It's nice to see so many familiar faces. And of course, for those of you who haven't met me before, hopefully I have a chance to meet you at the reception afterwards. I'm a third-year student here at Boyd, and as Dean Hamilton mentioned, president of the Gaming Law Society. And we're very excited about this speaker series. We're going to have 4 speakers roll out throughout the year, and we couldn't do any of this without Professor Cabot. So I want to give a special thank you to him for helping us do this and also allowing the Gaming Law Society to be a part of it. Before we get started, I do want to give a couple other thank yous, so please bear with me. I want to thank our sponsors, the Association of Gaming Equipment Manufacturers, the Nevada Resort Association, and the Nevada State Bar Gaming Law Section. And I would like to give one special thank you to Dean Smith and Kia Jackson Hale for helping us work with us to get everything together so fast. As I mentioned, we're very excited about this distinguished speaker series and especially appreciative and grateful that Gaming Control Board member Terry Johnson was willing and able to be our first speaker in this series. Before I invite him up, I do want to highlight one thing that Dean Hamilton mentioned, which is Member Johnson's stout commitment to the Nevada community. As he mentioned about his, prior to being appointed to the Gaming Control Board, Member Johnson was served in the State Labor Commissioner and in the cabinet of former Nevada Governor Kenny Gwinn. He was the assistant director at the Clark County District Attorney's Office and has been repeatedly recognized for his pro bono work, including being awarded Pro Bono Attorney of the Year. In Nevada, gaming is at the heart of all of our industries, and how we operate here serves as an example to the international gaming world as a whole. So in short, Member Johnson's work for the Gaming Control Board is a continuation of that service and the service to the Silver State. I've taken up enough time, so please join me in welcoming Nevada State Gaming Control Board member Terry Johnson.
All right, good afternoon, everyone. And thank you for having me. And a special thank you to Professor Cabot, not just for the invitation, but for the work that you have done on behalf of the gaming industry and representation of persons in that industry. It's certainly commendable work. It is an honor for me to be back here and to be in this room. I do have some flashbacks of sitting in that seat in Tort's class from a few years ago. So it's interesting to come back and be standing up here in this position. Another role reversal that I'm looking forward to as well is a lot of your faces are familiar to me. I'm used to asking the questions. So I'm looking forward today to hearing some questions and looking forward to that dialogue, because we don't get an opportunity like this very often to have Q&A with the students, with the gaming bar, the manufacturers, and others out there. So I'm looking forward to that discussion, looking forward to that dialogue. And I want to thank the sponsors of this event as well, the Gaming Law Society, AGEM, the Resort Association, and of course my alma mater, UNLV. So with that, I am going to go ahead and get started. And I will make certain that I leave enough time for that Q&A. And so what I'm going to do, because I know we've got a good mixture of people. We've got some law students, we've got some non-gaming attorneys, we've got some gaming attorneys as well as some professors, including one of mine here in the audience. So I'm going to try to cover all bases and just give an introduction real quick of the system, the regulatory system that we have, a little bit of an update on where the gaming industry is here in Nevada, talk about some of the regulatory issues that the professor asked me to touch on, and as well, hopefully honor his request fully to give some, I've been debating what to call it, advice, practice tips, pitfalls to avoid, I'm not really sure. But information on effective legal representation is what he called it. And then, of course, the Q&A. So just real quickly, because I want to lay some foundation, because it'll go into the rest of the conversation, and it'll be helpful to have that foundation. But this is our gaming regulatory system here in Nevada. You have the governor who appoints members to the Gaming Policy Committee, and he actually serves on it as well, a body that makes public policy recommendations to the legislature and to the Gaming Commission. You have the Gaming Commission, which is a 5-member panel, and our distinguished alumni and my colleague, Sandra Douglas Morgan, the most recent appointee to that. And I think it's a remarkable accomplishment as well for the law school dean to have members of the law school serving, alumni of the law school serving on the Gaming Commission and the Gaming Control Board to make sure we've got all bases covered for the whole team. The Gaming Commission is the policy-making body, and I'll talk a little bit about the differences between the Gaming Control Board and the Gaming Commission, because I get asked that question a lot. But the Gaming Control Board is the entity that oversees the day-to-day operations, those various divisions listed there, including our enforcement division, basically our in-house police department. Those are licensed, sworn law enforcement officers, our investigations folks who travel the world, looking into the backgrounds of people desiring to get into gaming, and our technology, licensing, and our audit divisions that collect the money. And I'll show you a little bit about how much they collect in a minute and where that money goes, and kind of our operations unit, that administration division. So about that regulatory structure, the Gaming Control Board and the Gaming Commission, I am one of 3 members that serve on the Gaming Control Board, and incidentally, 2 out of the 3 members are attorneys. And on the Gaming Commission as well, of those 5 members, 3 out of the 5 are attorneys. And so 3 out of the 8 combined all attended Boyd Law School, either for a JD or LLM. But the differences between the 2, the Gaming Control Board, that's your investigative prosecutorial unit. We do the law enforcement, whereas the Gaming Commission, in this sense, they serve as the judge of matters brought forward by the Gaming Commission. The Gaming Commission as well is responsible for the policy making. They have the only power to adopt regulations that have the force and effect of law that govern the gaming industry. And the Gaming Control Board is responsible for implementing those policies. The Gaming Control Board as well is responsible for overseeing the day-to-day operations of those divisions that I just mentioned a few moments ago. Whereas the commission does not get involved in day-to-day management, but at the end of the day, the Gaming Control Board proposes, the Gaming Commission disposes. You by and large cannot get an approval of any gaming-related matter without going through the Gaming Control Board in order to get to the Gaming Commission, and the Gaming Commission has the ultimate approval authority on all matters related to gaming. Now, I mentioned checks and balances because we haven't been able to come up with a better term, and I just stole it from someone. But what that's referring to is that between the Gaming Control Board and the Gaming Commission, if the Gaming Control Board recommends an applicant for approval, the Gaming Commission can still approve or deny that by whatever vote they take, 3-1, 3-2, whatever. But if the Gaming Control Board recommends a denial of any type of gaming approval, the Gaming Commission can only approve it and overturn that denial if they vote unanimously to do so. So it kind of creates a system where those two bodies kind of keep each other in check, so to speak. But it requires a unanimous disposition by the Gaming Commission on a denial recommendation by the Gaming Control Board. And so it's my understanding in the last 60 or so years, that has only happened twice in the last 6 decades, where the Gaming Commission has overturned a denial. And so I guess you can glean from that, if you have received a denial from the Gaming Control Board, statistically, odds are not in your favor. Because you're less likely to get that matter overturned. Not impossible, but just statistically improbable. The other thing about checks and balances is that where you have a chairman of the Gaming Commission, chairwoman of the Gaming Control Board, those positions, they have a lot of inherent authority to them, but there is also the ability for other members of those panels to kind of serve as a check, so to speak, on the chairs of those bodies. So if you go to the Gaming Commission chair or the Gaming Control Board chair for an approval that the law or the regulations might allow for, if they decline to grant that approval, you can take that to the full Gaming Commission or the full Gaming Control Board. In contested matters as well, if the Gaming Commission chairman makes an evidentiary ruling, including or excluding certain evidence during a trial, the balance of the members of the Gaming Commission can actually call for a vote, essentially, of those determinations and overturn that determination made by the chair. So that's what I refer to when I talk about checks and balances. Real quickly, this is what the gaming industry looks like today. People tend to think of it as casinos. And granted, that's a significant portion of it, but it is far from the only portion of it. So we have a little under 2,000 restricted licensed locations. Those are places, taverns, bars, laundromats, liquor stores, convenience stores, any place that has 15 or fewer slot machines compared to non-restricted locations. We have 443 statewide. We also license manufacturers, distributors, those slot route operators, service providers, anyone that touches gaming. Any service they provide to a gaming licensee, we will in all likelihood license them and regulate them, because the law requires us to provide for strict regulation of all persons, places, and things related to the operation of gaming. And these numbers have actually been fairly stable. I looked at the last 5 years worth of data, and I think there have been a little bit of change in the restricted licensees, but where the biggest changes come from are those service providers. 5 years ago, there was only 21. Today, there's 36. And those are people that provide technology services, consulting services, anything that might require licensing approval. But it's been fairly stable over the last 5 years. Unlike the gaming collections, this is how much we collect on behalf of the state in millions of dollars. So you'll see going back 10 years, we were just prior to the Great Recession at $980 million a year in gaming collections, those tax revenues. And we obviously had some dips in the ensuing years, but it's been rebounding the last couple of years with fiscal year 18 ending a few months ago with $866 million in collections. And so how does that get allocated? Where does that win come from? You'll see here, and it's amazing to me that we still have penny slot machines, but that's about a quarter of it right there compared to the other slot machines. And you'll see there's been a lot of talk about sports betting, and I'm going to talk a little bit about it too when I talk about the issues, but you'll see that as a percentage basis, granted the dollars are big, but as a percentage of the total, in Nevada it's actually very small. So I know there are a lot of states around the country salivating at the prospects of sports wagering, but you might be prepared for some eye-opening. So a couple of issues that I'm going to talk about. I mean, there's no shortage of issues facing the gaming industry, but I'm just going to touch on a couple of them. Security and safety is always going to be at the forefront of issues that we're dealing with, and we're going to continue to be good partners with our industry operators to provide safe and secure facilities as best as we can for as long as we can to ensure the security and safety of gaming patrons. Sexual harassment is one of the issues that we've been talking about a lot at the Gaming Control Board. The chairwoman of the Gaming Control Board has proposed a set of regulations to govern sexual harassment issues in the gaming industry, and tomorrow morning at 9:30 a.m. There will be a workshop held for the purposes of reviewing those proposed regulations and receiving further public comment on the same. Marijuana and gaming. So it's ironic, at the time they were approving medical marijuana a few years ago, back in the 2013 session, there was some discussion that the Gaming Control Board would assume responsibility for licensing and regulating members in the marijuana industry. We didn't have any enthusiasm for that. We just thought it was important to keep marijuana and gaming separate. Just a whole assortment of issues, which I can talk about as we get into the Q&A as well. But we've been dealing with those issues for the last 5 years now, and they continue to evolve, whether it's employee use of marijuana, whether it's persons getting involved in marijuana and gaming. But we made the policy statement that they should be kept separate because we wanted to ensure that there were no issues with money laundering, given that the marijuana industry is still not yet able to participate in the banking industry. We wanted to make sure that gaming assets was not subject to forfeiture in the event of a federal prosecution. But we also wanted to make sure that the people we license and expect to run gaming establishments would not be caught up in any adverse criminal activity, thereby taking them out of those licensed operations. So we continue to deal with questions on gaming and marijuana, and I don't see that abating anytime soon. Esports I'll talk about here, and also sports betting I'm going to come back on as well. But esports, so you know that esports is basically competitive video gaming, and it's something that's taken off in significant popularity in the last couple of years. And I think as regulators, we need to be prepared for some of those issues, because we, under Nevada law, permit wagering on esports activity under Reg 12.120, and they're categorized as other events. And so this industry is, as I said, extremely popular. In 2017, it had $655 million in revenue, projected for $900 million as an industry this year, getting up to, depending on who you talk to, I saw Price Waterhouse had an estimate for 2020 by about 1.6 billion, 1.7 billion. This figure, I believe I got from Forbes, projecting 1.4 billion by 2020. So it is definitely a growth space, and as regulators, we will be needing to deal with those issues, because one of the challenges is that there's no central regulatory body over esports, and so you're going to have a patchwork of state-by-state regulations, but who you deal with and who you go to on some of those concerns is something that I think is going to have to be sorted out. There are also those issues of integrity dealing with esports, whether people purposefully throw matches that people are betting on, for example, whether sabotage is something that occurs where people electronically undermine their competitors or undermine the person against whom they bet, I guess, and also making sure that the developers don't somehow undermine the manner of operation of the systems too during the course of some of the tournaments. And I think as well, if people are going to be wagering on esports activity, there is going to need to be a provision for patron protection. I mean, here in Nevada, we have a fairly robust patron protection scheme where if a patron is aggrieved by an act of a licensee, they can ask for an investigation by the Gaming Control Board. They get a hearing, goes all the way up to the Gaming Control Board members themselves on appeal, and that matter can go on to the district court and on the appellate channel. But nationwide, I think there's going to need to be some attention paid to patron protection. And the thing that I think is going to be important too is ensuring that there's some responsible gaming mechanism for the young people, especially, that get involved in the sporting activity of esports and might also be interested in wagering on it. I mean, these are folks whose maturity obviously hasn't fully developed, and we just don't want them to fall prey. And we have some good operators here in Nevada who do a really good job with their responsible gaming initiatives, and I think that's something that's going to need to be on the mind of policymakers going forward. So something I did not know until the last few weeks that I started looking into this, but there are colleges around the country, a few dozen of them actually, that have esports teams at the universities. So basketball, football, all the other sports. You can also go to a college and engage in esports and your extracurricular activities. And so this group, NAC, National Association of Collegiate Esports League. So NACEsports.org is their website, but they are the body that coordinates activities from university to university. And so they've gone from, just in the last few years, from about 7 or 8 schools that have participation in this area to about 80 or so schools, and so about 1,500 students. But yes, you can go to college and join your college's varsity esport team. I'm unfortunate in saying that our alma mater here does not yet field an esports team, but hopefully that will change. However, if you are interested in getting your young people started on this avenue, perhaps as a means of financing their education, number one, the prize pots are significant. I mean, there are people playing in these tournaments that literally are millionaires, 18, 19, 20 years old, earning several hundreds of thousands of dollars a year in tournament winnings. It is very big business, but you don't have to wait until they go off to college. You can send them to esports summer camp. Because according to the Washington Post just yesterday, the next generation of professional video gamers needs good posture, limber thumbs, and to know how to talk its way through a post-game interview. So esports summer camp is an option if you want to get them started young enough. Sports betting, this is something, as we know, that's taken off across the country, but it is going to require a lot of collaboration and information sharing between the sports leagues, between the regulators, the sports books, states talking to each other, and also some of the financial institutions, because the greater opportunities you have for that wagering activity, the greater opportunities you have for risk and fraud and attempts at money laundering and matters along those lines. So everyone is going to have to work together on the same page. And as far as the regulators are concerned, you definitely want to have a good working relationship with the schools, because that's where you're likely to detect irregularities first, with the schools themselves. And if the sports books as well notice suspicious bets coming in on a team, they tip off the regulators and they collaborate to investigate, and that's what happened here in Nevada a few years ago as well. We're also going to have to deal with issues about information privacy and data protection, because when people open up wagering accounts for the purposes of betting on sports, we provide information to the sports bettors. We've seen and experienced a lot of hacking over the last few years, and as I said a few moments ago, wherever you have those expanded opportunities, those will be opportunities for law-abiding persons, but as well opportunities for those who do not choose to abide by the law. So information privacy and data protection is going to be important, because you're seeing the mainstreaming of sports betting. I mean, you hear on ESPN talking about bad beats and showing how people lost because of a last-minute field goal and how much money was lost on a bet. Or you'll see, except for NFL games, but you'll hear people talking about the point spreads. So betting has gone mainstream, and it's a significant revenue generator as well. For us, with nationwide betting spreading as it is, we want to make certain that we are not involved in a race to the bottom, because what's going to happen, and a possibility I should say, is that you're going to have different states licensing sports bettors, and those licensees are going to be operating in those states, and they're going to get their licenses to go into business. Then they're going to come to Nevada, and they're going to say, hey, out in X state, we're allowed to do this. Why can't we do it in Nevada? And this state, we get approval for this software system, we want approval for it here. Well, Nevada has its own standards, gold standard, as we like to refer to it as. And so we have to be diligent here in ensuring that after the repeal of PASPA and the proliferation of sports betting, that we maintain our high standards. And there will be a need for that continued innovation. A lot of things that have I think taken a hold in the last few years in sports betting, in-game betting rather, some of the creative prop bets that happen. Mobile wagering is significantly a factor, very successful. I think I've got some numbers on that here with me as well. And so those are some of the issues that we're going to face in talking about sports betting. But statewide here in Nevada, this shows you over the last 10 years these increases in sports betting. So in 2005, or 13 years, 2005, we're at about $2 billion worth of sports wagering statewide. And just recently, that number topped out at about $5 billion just for the state of Nevada. And so we'll see how those numbers fare as other jurisdictions come online nationwide with sports wagering, but it's been very successful here. And I think a big driver of that has been mobile devices. Being able to bet while you're on the premises of a licensed gaming establishment or elsewhere, that has been a significant contributor. So you'll see in 2013, just on personal devices, you have what, $780,000, from 780 in 2013 all the way up to $2 billion in 2017. And so the personal devices account for about 40% of the total wagers that are written. So sports betting is doing extremely well. Betting using personal devices is doing especially well. And we'll see how those numbers, as I said, pan out as we go forward with the proliferation of sports betting. So the federal government has taken it upon itself to discuss potential federal legislation related to sports betting, given the topics that are being talked about. The two leading senators that are talking about this, Senator Schumer from New York, Senator Hatch from Utah. Senator Schumer, his bill would provide a national framework where states are not required to participate in that scheme. I'm sorry, not required to adopt their own standards, but they would be allowed to opt into the federal regime if they so chose. The sports books would be required to use data that's provided by the leagues themselves, and only the leagues under Senator Schumer's proposal. As well, he has a component of his that would require responsible advertising, not marketing to minors, for example. And he also has proposed that people be provided information at the time they place wagers of the dangers of addiction of sports betting. And he would also require, under his proposal, that there be suspicious activity reporting that occurs by these sports books. So if there are transactions coming in above a certain dollar amount, for example, say $10,000, or if the money smells like marijuana, as they are trying to wager with it, I would imagine that as well would generate a SAR. And he is as well mandating in his proposal that there be information sharing between the government agencies, but also between the leagues, the sports betting operations, the universities, etc. So his framework that he has outlined so far is more detailed than what Senator Hatch has outlined. Senator Hatch is painting more so with broad brushes. He wants consistent federal minimum standards. He wants to avoid there being confusion on a state-to-state basis. He's talked about wanting to specify who can and cannot place wagers such as league officials, employees of the sports teams, executives of the sports teams, the players. I don't know if that extends to the family members or not, but he as well talked about avoiding the states getting involved in a race to the bottom. So both of those senators have proposed bills. Neither of them have been heard, but a week from today, there is a House Judiciary Subcommittee that will have a hearing on sports betting called an examination of sports betting in America. So that was announced this morning, scheduled to take place a week from today, if you would like to attend. All right, Professor, you asked me to talk about legal representation. So I'm going to break that down into a couple of different areas. One, I'm going to talk about enrollment to practice before the Gaming Commission and the Gaming Control Board. And then I'm going to talk about some issues related to representing clients in licensing matters, representing clients related to disciplinary matters. So first and foremost, for you prospective gaming attorneys here coming along, it does require enrollment before the Gaming Control Board and the Gaming Commission to practice. For attorneys, CPAs, other individuals, there are some exceptions. People that are appearing on their own behalf, or people that are appearing on behalf of the family, a family operation, as well as corporate officers appearing on behalf of the corporate entity. But the general rule is you must be enrolled under Reg 10 to practice before the Gaming Commission and the Gaming Control Board. It's a fairly straightforward process. I think the key thing here is that it's a revocable enrollment. So if there are issues of ethics, dishonesty, you can have your ability to appear before the Gaming Control Board and the Gaming Commission revoked. I'm not aware of any instances where that has happened. I can only tell you my own personal experience. There was one occasion where I thought an attorney was in an ethical quandary, either of the creation of themselves or their client, but it was a matter where they did not furnish information that was relevant to their application. It was material information. And as I watched them stand at the podium at the Gaming Control Board, what appeared to me was happening was the representative was trying to cover for the client on in one aspect, but also trying not to implicate themselves. And trying to walk that fine line, I don't think worked out very well for them. And that, I think, was the most danger I've seen a representative place themselves in front of. So there is a word of caution there to be had about ethical representation before the gaming regulators, and as well as your own professional reputation, because the legal field is a small field. I mean, first of all, Nevada is a small town. And a subset of that, the legal field, is a very small field. So you want to protect your professional reputation, and that's something you can never regain, or not regain easily if you squander it. So with that having been said, I'm going to give you a couple of examples of gaming laws versus general laws, because gaming licensing is a different animal, so to speak. So I'm going to give you just a few examples of how we have some general provisions in state law, especially when you appear in front of government agencies, but when you step into the gaming room, it's a little bit different of a scenario. And then, so public records is one example. The general rule is that a government agency has to make all of its public records, public information available upon request to persons. And I've given you the site for that. However, in gaming, that information is confidential and absolutely privileged. Anything that Gaming Control Board agents go out and acquire or is provided to them, if it's related to an application, approval, finding of suitability with very limited exceptions, such as through a court order, that information is confidential and absolutely privileged, and the general public is not going to see it on any given day. There is another provision recently added where the applicant or the licensee is the holder of the privilege and can actually refuse disclosure of certain information. And I think I have the site there, 463 of the NRS, 463120. So that's one difference between the general rule and the gaming rule. Another example would be open meetings. For your average government agency, whenever they meet, those meetings have to be in the sunshine of the public. The meetings are open and accessible under NRS 241. Any person that wants to attend must be permitted to attend. In gaming, however, closed to the public are investigative hearings and investigative proceedings, and that can take a couple of forms. Sometimes we have a statute that allows us to meet with confidential informants. And we can have a transcriber there, we can have agents there, attorneys there, but that is closed to the public for obvious reasons. Other proceedings where the members of the Gaming Control Board might want to convene for purposes of discussing potential or pending litigation and the settlement of that pending or potential litigation. And so those proceedings are closed to the public as well. So not everything there is going to be open to the public. The Administrative Procedures Act governs your average state agency, requires them to undergo certain processes before they adopt rules, regulations, very specific in its requirement. At gaming, however, the Gaming Control Board and the Gaming Commission are entirely exempted from the Administrative Procedures Act. And I think there's some good and bad to be had with that. The good side is it gives us a chance to enact new regulations quickly. We can usually do it in a couple of months' time. I had a licensee come to me a couple of years ago. Our auditors had detected that they were giving out merchandise and gifts and prizes to bettors that were inconsistent with the regulations. This was in the parimutuel context. And so it was a couple of months before the Kentucky Derby or Preakness or one of those events, and they said, yeah, we give it out to them as promotional devices to get them to come in and wager with us. So some auditors happened to be out there, saw it, and said, no, you can't do that. So they came in to meet with me. I oversee the audit division, and I told them, you don't have a problem with staff, which I think is what their concern was. You have a problem with the regulation. And so I said, what you want is a change in the regulation that would allow you to have greater flexibility in how much of a dollar amount you can give to your patrons in exchange for them wagering or coming on the property. And so they said, well, you know, the race is 2-3 months away, we don't have time, that's not started. So I offered to them, if you want to draft some regulatory changes, submit them to me. I will personally work them in the process. And we got it done. By the time the race came around, we have the regulations enacted and changed. So it works well in that sense. Where I don't think the exemption works beneficially is that one of the things you're required to do under the Administrative Procedures Act is to gauge the cost of your regulations. And regulations cost money to the regulator, to the regulated. We don't conduct that review in the gaming context, unlike other agencies. We also don't have a requirement to periodically review regulations. Other state agencies are required to review their regulations once every 10 years to see if there are any revisions or repeals that need to be had. But I look and I see gaming regulations that have been out there for 20, 30, 40 years that have never been revised. There's one example we touched on a couple of months ago at a board meeting where the statute says one thing and the regulation says another thing. They conflict with each other because the regulations were never revised. And so that's one of the downsides, I think, of being exempt from the Administrative Procedures Act. You don't do that housekeeping on an ongoing basis. A couple of other things, especially for the attorneys, when you are looking to get a decision of the Gaming Commission and Gaming Control Board set aside, and you go to the court to do so, under the Administrative Procedures Act, they're going to look to see if the evidence should be set aside because it is void of substantial evidence. In gaming, however, I'm sorry, that's a general rule. In gaming, all you need is any evidence. So I think everybody here, the students are beyond first year, right? So I don't know if you've had administrative law, but you've talked about, if so, the difference in the evidentiary thresholds or evidence, for that matter, between preponderance of the evidence, evidence necessary to establish something beyond a reasonable doubt. Well, here, any evidence, I mean, I don't know if it's possible to get a lower threshold than any evidence. All you basically just have to show up and argue the case on behalf of the gaming licensees, and you will find considerable deference given to that. And I think that was the legislative design to ensure that the deference is at its height, at its maximum when it comes to gaming regulators overseeing the gaming industry. Other gaming law aspects, I will go through these real quickly. This this is something I haven't seen in any other setting. I worked in a few government agencies over the years, but this is the first place I've ever seen where the agency has the ability to waive the application of a statute. The Gaming Commission actually has the ability to waive the statute. So the legislature has enacted a law, the governor has signed it into law, and written into that law is the ability of the Gaming Commission to say, for reasons of public policy, for reasons of practicality, we're going to waive the application of this. It's somewhat limited, but you will not find that. I'm not aware of it existing in any other agency. And so it's something to be mindful of for those looking to practice in the gaming context. The other thing is that virtually any transaction that affects a gaming entity requires approval by the Gaming Commission, whether it's financing, estate planning, which is just a whole separate problem because someone passes away, they pass their interest in a gaming establishment onto someone else. That person doesn't know that they need to apply for a license to be the executor of the estate. It creates a lot of problems, but also financing transactions are problematic too, because when we license an establishment, we want to make sure that the money is appropriate for the project at hand and that it comes from a suitable, reputable source. So financing transactions are always going to be important. But at the Gaming Control Board, Gaming Commission, you have to fund investigations. You pay for your background investigation up front. They'll give you an estimate. And those investigations can get into the low hundreds of thousands. I see some affirmative nods out in the audience, someone who's obviously signed a check for some of those. Those investigations can get into the tens of thousands, low hundreds of thousands, depending on the nature of the project at hand. But you pay for it up front. And if you don't pay for it, that can be a basis for a denial of the application. And once you get the license, you pay in some instances, not all, but you may be required to pay for monitoring. So there's a revolving account, as it's called, and so there might be a condition of licensure that you can get this license, but we want you to deposit $25,000, $50,000 into a revolving account for purposes of monitoring your operations on an ongoing basis. You don't see that too much as well. Bankruptcy is a special area as well. So if you are a gaming entity or you represent a gaming entity, you file for bankruptcy, you have to notify the Gaming Control Board and the Gaming Commission, because we have an active, ongoing, and vested interest in making sure, for example, you have enough money to pay out jackpots and other winnings, but we want to make sure that that operation has the money in it to function. But we also want to make sure, and this is where we get into some state and federal issues, because bankruptcy law is a federal law, and the bankruptcy trustee appointed by that federal judge as well, they are going to be responsible for overseeing the property, the assets of the bankruptcy estate. Well, if that happens to be a gaming business, a gaming location, that bankruptcy trustee needs to apply for a gaming license. And we have some issues from time to time on that, but they are still required. Third parties in gaming regulation, in that case, I'm talking about people that you do business with, must be beyond reproach as well, but they can also cause you some problems, especially in areas like nightclubs, the day clubs, what have you. You want to make sure that you're keeping an eye on those developments. And a rule too to be mindful of is that you must provide general access to the premises, the records, equipment, anything related to gaming. You need to allow access to the agents, whether they're out there doing routine work or if they're doing background work. They cannot be denied in general access to the information that they need. On patron disputes, keep in mind that the Gaming Control Board has exclusive jurisdiction over patron disputes. So if there is one, you can't go file civil suit against a party in court. You must exhaust your remedies at the Gaming Control Board, and then you go straight to court. You do not go through the Gaming Commission in that instance. And keep in mind as well that the technical rules of evidence do not apply in those proceedings. However, ex parte communications is still prohibited. I'll get a plug in for the pro bono program that the gaming bar has been very active in, where people who have been denied their work card, the gaming card, they want to appeal that and get a hearing before the Gaming Control Board. Those persons can be represented by pro bono counsel, and I have been an active supporter of those attorneys, helping them, and I appreciate and applaud their work. Mr. Silver has represented clients on a pro bono basis in front of the board as well. Some pitfalls to avoid. There is, written into the gaming law, for people coming forward to get an approval, every place else, I think you're presumed suitable until you show otherwise. In gaming, however, it is though there is a presumption of unsuitability. You are almost presumed unsuitable, and you bear the burden of showing your suitability for licensing. And I think sometimes attorneys don't fully advise their clients of that fact, and sometimes clients aren't fully aware of that, because clients will operate with this mindset of, yeah, I understand I didn't answer your questions fully or what have you, but that doesn't prove anything. And I'm very quick to point out to them that I don't have to prove anything. The burden doesn't rest on this side of the podium, is what I tell them. The burden rests on that side of the podium. You bear the burden of proving your suitability, because a license must not be issued. That's what the words of the statute, must not be issued unless a person is of sufficient character, appropriate habits and associations in their business and professional life. So there's a presumption of unsuitability in gaming licensing. The Gaming Control Board and the Commission have full and absolute power to recommend or approve or deny or condition or revoke a license. It is a revocable privilege. The reason I underscore the word condition is because that's where I think lawyers have an opportunity to help their clients. There are some circumstances where an application isn't quite clean, isn't quite there. And I think the good attorneys out there are good at creatively offering possible conditions to impose upon the license, requiring them to be drug tested periodically, requiring them as a condition of licensing to provide certain additional financial information. I think the effective lawyers are creative in developing conditions, but the catch is, there really is no playbook. I mean, we as board members, when we're sitting in real time, we actually literally have a book that has standard conditions in it, is what we call them. And so for most of them, we kind of flip through, okay, yeah, let's put this on here. They have to take a class. They have to provide this information, what have you. But for the most part, there is no book. There is no list. It is up to the attorneys to be creative enough to propose solutions that can condition the license that would meet with the satisfaction of the Gaming Control Board and the Gaming Commission, because the statute gives those bodies wide discretion to condition that license in any manner they see fit. And you will bear virtually zero chance of success at trying to appeal a determination that your license should not be conditioned the way they have recommended. I talked about bankruptcy of gaming entities, so I'll skip to know your client, because I've sat there and I've watched attorneys there, and it's a difficult environment because you're taking live fire, and I've seen that look on the attorney's face when somebody on the board asks the client a question, and the attorney looks at the client, and the client looks at the attorney, and nobody saw that coming. And so it is a very intrusive process. Those agents that do the investigations will leave no stone unturned. Really none. They will look at who is in your family, who counts amongst your business associates. And interestingly, there's a regulation that puts persons on notice that the applicant bears the risk of, quote, adverse public notice, embarrassment, criticism, or financial loss as a result of the interchange between the board and the applicant, the commission and the applicant. So for the attorneys, you have to vet your client, or there will be unpleasant surprises. No one's setting out to get you, but things come up and questions get asked, and sometimes people aren't truthful either. So you have to know your client and prep them properly. From time to time, we'll get calls from the attorney saying, hey, My client had this issue back 5 years ago, and they'll call like the day before the meeting, and they'll say, you know, they would appreciate if you didn't ask them about this during the board meeting. And so say, all right, counselor, hey, thanks for calling. We'll see you at the board meeting. And so, you know, we just don't do it. You can ask, but you need to know that if there's something pertinent to that individual's character, finances, background, associates, family, and it gets difficult on some days because there's some very difficult issues that people have to deal with. Also, be prepared to interact with the staff. You know, they're fine men and women at the Gaming Control Board, and your interactions with them go a long way in terms of how those matters are handled. I include this as a point of advice and as a potential pitfall to avoid. I want to talk about the role of the chair because there just seems to be misperception from time to time about the role of the chair. And the reason I say that is that I've had attorneys come up to me and they'll say, oh, I've got this item on the agenda coming up next month, what have you. I already talked to the chair about it. They said it was okay. And so, granted, I was never one who excelled in math, but what that tells me is that you've secured one of the at least 2 votes that you need in order to advance the matter forward. And I've never quite understood why persons operate under this, but it's something to be careful of because you can get in front of the board or commission, and if you haven't kept those persons appropriately apprised, it could be problematic for you. And take advantage of board member availability. I mean, I make myself available if people want to come down and talk about an application that's going to come up, background investigation. I have no problem with it. Matter of fact, I've had a couple of times where the attorneys will call me a day or 2 before the board meeting and just, hey, I just want to check in, any issues, any problems. I won't give them the whole thing because sometimes you get a little bit of surprise. But other times, if they ask, you know, hey, any thoughts, any concerns, I will at least tell them this is the area of questioning that will unfold at the game. This is what I'm going to talk about. I'm not going to tell you the questions I'm going to ask, but these are the areas that I'm most interested in. Their financial dealings in XYZ state or what have you. And then this is a recommendation that came from staff. From time to time, attorneys will submit position papers or memoranda on behalf of their clients, particularly if it's a novel question, a legal issue that hasn't been previously decided, or a novel application that has not been previously granted. Everyone there appreciates when they develop that information and submit it as part of their application. Other topics in disciplinary matters, same thing. Remember that the chair only has 1 vote, but this is particularly important that you have to know your forum because a lot of attorneys appear before the Gaming Control Board, especially in disciplinary matters, and they just kind of start having these, I don't know, Law and Order, Perry Mason flashbacks, and they act as though they're downtown. They act as though they're in district court and they are, I think the term is showboating, as if they are standing in front of a criminal court proceeding or standing in front of a jury that they're trying to wow and impress, and that doesn't work well in the Gaming Commission, Gaming Control Board. So you have to know your forum. There was an attorney who represented a client a few years ago in a disciplinary matter. I recognized the attorney. They were a family law attorney, and I will just say it did not go well. On behalf of your client. So know your forum. I've given you some examples of how things are different in a gaming context versus general administrative law or criminal proceeding. So make sure you know your forum. Ex parte communications when the commissioners are sitting as judges. Ex parte communication with them is prohibited. And as in other civil settings as well, there are sanctions that apply for persons who violate that, the attorneys. And so I think this is probably the last thing. Factors for imposing discipline. This is where I think attorneys can do a really good job on behalf of their clients when they want to either settle a matter or if they want to argue why the maximum penalty should not be imposed. There are factors that are employed that have been developed and memorialized, and I'll give you the site in a moment, for imposing discipline. So just FYI, I think if you have a disciplinary matter, you would be well served and you would serve your client well as your organization by being aware of these factors that go into the discipline imposition. One is whether the licensee knew or should have known that the violation occurred. The second is whether there was a record of any prior disciplinary action. Another one is whether or not the licensee relied on the advice of legal counsel or other professionals, a physician, which comes up in the context of marijuana, including medical marijuana, or in the context of some of their financial transactions, their CPA would be considered a professional whose advice they relied upon, and it caused some adverse regulatory issues. But that is a factor in determining the discipline to be imposed, whether or not they had a compliance plan that had been reasonably constituted and was in fact functioning versus a compliance plan that was sitting on the shelf. And they look at whether the penalties are proportionate to the violation that occurred, also where other licensees have been disciplined to see how the disciplinary action compared with that, and then any other mitigating factors that the licensee might offer or have offered on their behalf. This is about a third of the factors to be considered, that could be considered. If you want the full list of them, there's about 19 of them. They're at Nevada Gaming Commission Regulation 7.240. And that's where I think attorneys do a good job in providing effective, ethical, legal representation for their clients in those disciplinary proceedings especially. So, did I hit it, Professor Cabot? Anything else? All right. So, hey, your turn now. Sir?
All right, so going to esports, on your slide you said there's concerns about the unregulated nature, concerns about the integrity of esports, software concerns and all that. My question is, how do you entice a video game company, Microsoft, Activision, Blizzard, Nintendo, to voluntarily consent to not just being regulated by our Division of Technology and Gaming Control Board, but the approximately 360 jurisdictions worldwide?
All I can say is to be determined. I think those are some issues that as that industry continues to expand and have the financial success that it does, and particularly the involvement of the young people, and when those parents start seeing some of their credit card bills, where the kids have charged some gaming charges to there as well as the esports, I think that is going to accelerate the conversation. I don't know if any of you saw the 60 Minutes piece where the kid got a hold of the parent's credit card and was playing Counter-Strike or something and ran up thousands of dollars in charges. But it's a valid point, and at this point, I don't know the answer to that. It is something to be determined.
I have a question about how you approach whether or not to allow wagering on esports or a particular esport event. It's particularly concerning to me because there's no central authority that is actually governing esports. And you're dealing with sometimes kids who are 18 and 19 competing as opposed to professional athletes. So I'm just wondering what's the approach of the board towards authorizing wagering on these events?
And I'm not sure how many, if any of those we have authorized since we made those amendments to Reg 22, but it's one of those areas where the lawyers will appreciate this. We know it when we see it, but I meant to put that on one of the slides, that we are going to have to look at the age issue because a lot of the players are under 21, yet we require persons to be 21 or over to be in a gaming establishment, to be involved in gaming. And I think some of the factors that you heard mentioned in other contexts will be applicable here to it, just in terms of trying to safeguard the integrity, conducting some minimal diligence at least to ensure for the integrity of it. If that means nothing more than educating persons, the participants, on what their ethical obligations are as part of the approval process to make sure it's conducted in an upright manner, because we would not forsake our obligations under state law and state policy to ensure gaming is conducted honestly, competitively, openly. So those policy factors would guide our evaluation of an applicant looking to come forward for an approval, and we'll just have to apply it on a case-by-case basis until we can come up with some criteria. It's similar to what I think has happened with marijuana. The different questions that would come out about marijuana over the last 5 years, we just could not anticipate. But after a couple of years, we started to see some patterns, and were able to, I think, make some more general recommendations to the industry. And I think we'll probably have to do the same thing with esports to work with our partners out there, ESIC, Esports Integrity Coalition, that we entered into a memorandum of understanding with a few years ago to just kind of work collaboratively to highlight issues, have a reporting mechanism if we see anything suspicious or if the players see anything, to report it to the licensee if it's happening on the premises. That is going to be a work in progress, but it is a work that must be done. Mr. Silver?
I've got a question about the dust up from about 2 years ago, 3 years ago, about fantasy sports. And I know that Nevada has taken the position that fantasy sports is gaming, and therefore, if you want to engage in fantasy sports, you need a license. Other jurisdictions haven't been as sure about this. Some follow Nevada, others have turned it over to the regulation over to the Department of Agriculture in their state, so they're not as serious about it as maybe we would be here. So with the passage of the sports wagering Murphy case, are you going to take another look at fantasy sports and see whether or not some of the arguments they're now making about this as being a skill-based game have any merit? And if not, how are these fantasy operators going to be able to operate in Nevada? They're going to require a sportsbook license where they have to be a part of a brick and mortar casino. There isn't going to be any online type of wagering independent of that. So maybe I thought maybe you could give a little discussion.
Sure. I'll give you my individual assessment. I don't anticipate we would be revisiting that issue anytime soon. We made the determination that it did constitute gaming, and if you wanted to do it in the state of Nevada, it would require licensing. I would imagine that they would instead, they being the daily fantasy sports operators, would prefer instead to focus on either a national regulatory scheme or focusing on perhaps the larger states, because Nevada is still a small state in population compared to California, New York, what have you. So I would doubt if they want to have 40, 50 different state regulatory regimes that maybe, I don't know, maybe as part of the congressional discussions on sports betting, they'll include a component on daily fantasy sports. But I don't really know what else we could do or could say. I remember at the Gaming Policy Committee where Governor Sandoval asked the representatives of the daily fantasy sports basically, okay, what if the current regulatory system doesn't work, what do you suggest? What do you propose to make it more amenable to your business model? And if I remember correctly, there wasn't much of an answer provided.
It was pretty weak.
Professor Rowley.
So let me ask you about one of your hot topics, one of mine. Sexual harassment. It's one of the things that was up on your screen. I've wandered through a few casinos in the last 17 years, and I've seen some pretty provocative illustrations on certain game machines, to put it mildly. Sexually demeaning might be another way of putting it, which one would think might create a hostile environment claim. Is that something that you all will be taking a look at as you are addressing sexual harassment in the gaming industry?
I have not heard that mentioned in the context of the current sexual harassment discussions. But when there is a theme, particularly for slot machines or other games, our technology division, they are the ones who vet those and make sure that they are up to the standards that we would employ here. And if there is an issue in the approval process, they'll kick it back and not approve it, or they'll escalate it up to the board members for their review. And if the agents are out in the field and they notice something that merits attention, they'll report it back as well. But I haven't heard that come up in the context of the current sexual harassment discussions.
And my other question is virtual currency. There's probably a straightforward answer to this, and it may have already reached a decision that I just don't know about. Can a casino accept a bet in virtual currency, cryptocurrency, whatever you want to call it, Bitcoin or something like that? Must it accept it? And if it does accept bets in virtual currency, when the player cashes out, does it have to pay them back in virtual currency? Or can it pay them back in US dollars?
Sure. So I think I can.
It's a double gambling situation, right?
I think I think I can answer your latter questions by just answering the first one, that no, we have not permitted licensees to allow for gambling with cryptocurrencies. That question did come up. I think we said you can have them, spend it at the gift shop or the flower shop or whatever, but not for purposes of gaming. So that question has come up and has been answered.
So as I start, you talked a little bit about the social game or the responsible gaming.
Yes.
For especially the 18 millennial age, that type. So I start seeing more and more of these partnerships that are coming up where odds and stuff are being displayed at games that are considered family oriented. And then of course they're going to, I'm sure, as in other states, and I'm sure we won't see it here anytime soon, but they might be in other locations that might be a lot of family might normally be. Is that something that the board might be interested in, at least monitoring as to what kind of information is displayed? Is it possibly enticing these minors to start looking at gaming in a different way?
Yeah, there is an existing regulation in Regulation 5 that I believe it's 5.011, that talks about the need for advertisement to be conducted in a decent manner. That is probably one of the more difficult areas to regulate because of the implications of constitutional rights. But we do have an existing regulation that speaks to advertising, and we also have regulations that speaks to not illustrating I think the play in a manner that would be enticing to children. So sometimes we'll get cartoon themes for a slot machine or something, and that will get kicked back. It'll be interesting to see what happens at the federal level too, between those Senate proposals that are out there, to see exactly how far are they willing to go. Because I think we'll be watching that conversation where they have proposed for advertising standards for sports betting generally. And I think that could have some spillover to how we analyze slot machine play, or table games not really an issue. Usually it's the slot machines and the themes that accompany those slot machines. But we do have an existing regulation, and we do enforce it, and we do vet those approvals when they come through to ensure that they are not inappropriately appealing to minors. And that's another one where there is no set playbook. You just kind of know it when you see it.
Well, and then to further that, of course, we're seeing a lot more conversation, especially on the European side, about other areas of gaming that is becoming a responsible gaming issue, like the Candy Crushes of the world and the other social gaming aspects and so forth. I mean, are we going to start seeing more loot boxes? Are we going to start seeing more regulations on that, or is that just something until something happens?
Yeah, I haven't heard of anyone in our organization taking that up as a regulatory topic. As I said, I think we'll monitor some of the other federal conversations, and we do hear from some of our international licensees about some of the things that they can do in other jurisdictions. But we have our standards here in Nevada. We, I think, work very diligently to try to maintain those standards, and I don't see anyone retreating from that anytime soon. Sir?
Yeah,
It's like you get the last question.
I'd love to piggyback on that if I could.
Okay.
I'm very interested in, I guess for lack of better word, non-traditional gaming. And I think with esports, you're going to get a whole host of young individuals who are interested in, card tournaments that are not poker, with different kinds of card games, board game tournaments and things like that. And I'm wondering if the control board has given any thought to whether they will classify those as gambling or a game of skill.
I'm not sure I'm familiar with the examples there.
So, maybe board games like Settlers
Oh,
of Catan, or tournaments for games like Magic the Gathering or other trading card games.
I think if it is subjected to the analysis of whether it constitutes gaming, similar to how we did with daily fantasy sports, we'll make that determination that it is gaming and that licensing is required for it. And we understand that there's going to be some give and take as we go through this analysis, because on the one hand, the industry is challenged with trying to recruit a new class of gamers, right? The millennials are not as attracted to gaming as the generation that preceded them. And so on the one hand, there is that desire to attract them, but on the other hand, you recognize that younger people especially might be more susceptible to some adverse outcomes from gaming. And how we balance that is going to be a delicate balancing act, but at the end of the day, we have a charge to keep in terms of maintaining the integrity of gaming, maintaining the reputation of gaming here in the state of Nevada, and we're not going to do anything at any time to compromise that.
Thank you. I'd like to thank everyone for coming.
All right.
Please join us outside for reception. Thank you again, Member
Thank you
Johnson.
for having me. Thanks. See you.
Throw it out there, so following up on it.
Okay, all right, so, and then I'm saying,
I know most of the dates, I know it's,
okay,
it's coming to
all right, I'll have you guys keep it. Manufacturer.
surprisingly, yeah.
So if we make a decision, well, we can't call forth Microsoft.
I think great job.
That's the easy part.
So we're gonna get manufacturer, be like, well, we are aristocrats in all software. Why do we have to submit our software to tech and they don't? Would that even be?
Last time I was in bed, we had trying to summer. Yeah. I don't know yet. Didn't know it this will happen, but I think it's I'm trying to get ours like, oh, okay.
Oh, that's how we got it.
I know, 20 days for results.
Oh my god. It's like, alright, you'll all shut up or you won't hear.